Good afternoon. Good morning, everyone. Thank you for joining us today for our 2024 year-end compliance update. My name is Craig Kavarik, and I head up our employee benefits and executive comp practice here at the firm. And we're very glad to have you. Let me do a couple very quick housekeeping matters. At the bottom of your audience console, there's multiple application icons for use during the program. If you have any questions, you can type those to us and we'll do our very best to answer them live if we know the answer. If we run out of time or we don't know the answer, we promise we will absolutely get back to you. There's a PDF with the presentation materials. It's under the programs material folder, and you should be able to click on that if you'd like those slides. And if you have trouble getting those after the presentation, just shoot us an email. We'll absolutely get these to you. And then at the end of this presentation, there's always a short survey, and we very much appreciate your thoughts and any constructive criticism or suggestions for future presentations. And then we have this is being accredited for continuing legal education, and in certain states we have to do a little quick survey. So we have a couple of survey questions built into these slides, and if you'd be kind enough to click on those, and if you are getting CLE credit, it's important that you do that. So we'll get started. Let me introduce my colleagues, maybe if I can get my okay. Here we go. So I can't not see the slides. You all see the slides?
Yep.
Okay. What slide are we on, Molly?
Too far, my friend. So let's back us up. There you go.
All right. So here's my colleagues. Molly Hobbs is a partner in our Denver office, and Molly's a compliance ERISA type, just like me. So she and I have a very common practice. She has particular experience with health and welfare matters, but really all things ERISA. And then we've also shaken this up a bit, and we've invited Melissa Barris, who's again one of our partners, and Melissa is a litigator. So she litigates all types of matters, commercial litigation, but has a particular expertise with ERISA litigation, and she's our go-to person, one of our go-to people for ERISA matters. And so we thought we would include her. Again, Molly and I focus on compliance and advising employers on the business aspect, but we thought it would be fun to bring in Melissa. And again, we're all striving for the same thing, and litigation can be scary, that's, along with our theme. So we will kick it off. So why don't you kick it off, Melissa, and we'll get going with this presentation.
All right, thank you, Craig, and good afternoon, everybody. I like to call myself Melissa ERISA for no other reason than that it rhymes. But we're going to start by talking about some ERISA litigation, which is kind of the spooky stuff, all the kinds of troubles that a plan can get in. And then Craig and Molly will give you some best practices as how to avoid seeing yourself and your company in litigation. So just kind of to set the stage first, if anyone's not familiar with the ERISA litigation, the main claims that we're seeing and the ones that are getting the most publicity these days are the 401k plans, where the employer offers a plan for 401k benefits and the employee's money, the participant's money's in the plan, and the employer, as the plan administrator, is the fiduciary that is managing or has control over those assets. So ERISA imposes upon plan fiduciaries a duty of prudence with respect to plan investments. And a duty of prudence is the duty to act as a reasonable person with respect to the plan and the plan assets. And as we're going to talk about in detail, the duty of prudence includes a continuing duty to monitor the trust investments and remove any that are not prudent. So it's not just a duty to select prudent investments on the outset, but to continually monitor and remove investments that are not prudent from the lineup. And the other aspect is that a prudent fiduciary can only incur costs and fees and expenses that are reasonable and appropriate. And again, that's not just the fees when you hire a service provider on day one, but it's a continuing duty to monitor and control costs and fees. So we're going to talk a little bit, and I understand not everybody is a litigator, but the main issue really these days is what a plaintiff has to plead in order to state a claim, in order to make it through the threshold and survive a motion to dismiss. And that's really where the fights are, because different courts have different, are stricter than others about what they will allow to proceed. Because if a case proceeds past a motion to dismiss, then the next stage is battles over class certification. It's battles over whether it's causation. And that's when it starts to get, blow up into expensive litigation and you see settlements. And I'm sure everybody's seen the publicity of, multi-million-dollar settlements of plans that didn't escape on a motion to dismiss. So wanted to start with a Supreme Court case from 2022, Husch versus Northwestern University. Not new, but it kind of sets the stage. In that case, the Supreme Court was presented with an opportunity to set some standards, but didn't really give a lot of guidance to plans as to what they need to do to escape these litigations. In that case, the plaintiffs alleged that some of the investments in the plan were imprudent because the fees and expenses of those investments were too high. And for other reasons, they were inappropriate. And the Seventh Circuit Court of Appeals said, well, maybe some of those plans had fees that were too high, but other investments had fees that weren't too high. And so, participants can invest their money in the ones that weren't too high. There's good choices that they can choose from. Doesn't matter if they didn't like the other choices. Supreme Court said no. The duty of prudence and the duty to monitor and make sure investments pertains to every investment in the plan. And the fact that there might be some good investments doesn't excuse the responsibility to remove ones that are not good. So the court held that the duty of prudence extends to all plan investments with respect to the fees and the performance. But then the court said it turns on the circumstances and it will be context specific, giving regard to the range of reasonable judgments a fiduciary may make. So on the one hand, as a fiduciary, that is a good thing that there's, reasonable range of choices, no hard and fast lines. But, in terms of litigation, it makes it a little bit tricky what needs to be alleged and what can survive. So now where we are 2 years after Husch is the lower courts kind of struggling to say what context and circumstances is sufficient to show that a plan fiduciary breached the duty of prudence, that they did not fulfill their obligation to monitor plan investments and costs. So that's where we are, and we're seeing it play out in the lower court. So in terms of the litigation, there's really two aspects that the plaintiffs need to show. The first is that it's more of a substantive, that there was prudent choices that were available, that the choices were not prudent. And that applies both, again, to the investment options that were selected and to the record-keeping fees that were paid. But in order to state a claim for breach of fiduciary duty because the investments were not prudent, you have to have a meaningful benchmark. The plaintiff has to say that the investment was not prudent. It didn't perform well compared to other investments that were out there, right? And it all depends upon the circumstance, right? Is the investment a similar size? Does it have similar goals? Does it have similar risk tolerance? Same thing with record-keeping fees. It's not enough to say, well, you paid $30 per person, but another plan paid $20 per person, so your fees were too high. Well, maybe the plans were different sizes. Maybe one plan paid more for a Cadillac range of services, where other plans had a narrow range of services, and there's nothing wrong with that. But they have to show that the prices that you paid were unreasonable compared to similar plans with similar service and similar sizes. And then the other aspect is the decision-making process. They have to show that the fiduciary did not engage in a prudent and responsible decision-making process. And that includes failure to monitor performance, failure to remove funds. And again, it doesn't mean that a fund has a bad month, you have to remove it, right? You have to be monitoring it and remove funds that consistently underperform. And also a same thing with fees. It's not that you have to be continuously, the cases will say you don't have to continuously scour the market for lower fees, But you have to be, putting out RFPs at some interval. You have to be monitoring fees, making sure if the plan grows and gets bigger scales and bigger leverage, are they negotiating better fees? So those are kind of the benchmarks that need to be shown to state a claim. And what part of what we want to talk about is what you as a plan can do to, if a claim is brought, to be on the right side of the lawsuit. So I think I'll pause. I've been doing a lot of talking and see if Craig and Molly want to chime in for a minute on, ideas as to these best, what the plan should be doing.
Sure. So I thought you did a great job. I mean, spot on. And I think we intuitively know all this. And we have a slide, sort of some key takeaways later, but it's documentation and benchmarking, right? And time flies, and I sit through many committees, and the next thing you know, the last time you benchmarked was 5 years ago or 6 years ago, and there's different ways to benchmark, but at a minimum, committees should be doing this every 2 or 3 years and really putting in their minutes and memorializing it, that they've looked at it, and if they aren't where they need to be in terms of benchmarking, document why and why you're comfortable with it, and there's lots of benchmarking services. If you use a consultant, consultants are usually on top of all of these things, but actually, documentation is the key.
Absolutely, because it's not just, again, a fee may be higher than another fee, but that may not be unreasonable if there is a reason. And so if you have some sort of reason why you're choosing a more expensive record keeper, maybe they have specific services your plan needs, that needs to be documented. So that, because when the fiduciary engages in a reasoned process and exercises its discretion, that's more likely to be upheld than if a fiduciary isn't engaging in a reasoned process.
And it's also an opportunity to improve your plan too. If we're paying fees that are higher because we have these additional services or bells and whistles, do we use them and do we value them? And if not, then let's cut them out. That's another opportunity to improve your plan. So,
absolutely, and it's interesting as a litigator. The federal courts, it's usually notice pleading. You don't have to plead a lot of facts in a complaint, but in these ERISA cases, they really are making plaintiffs plead the facts that the plan did not engage in a reasoned process, did not have meaningful benchmarks. It's much more of a detailed pleading than you usually see, which kind of begs the question, well, how's the plaintiff supposed to get all that information before they file a suit and got discovery? And so a lot of times you'll see a pre-suit demand letter asking for documents. And that's an opportunity. On the one hand, ERISA requires certain documents to be provided. On the other hand, everybody knows you don't want to turn over documents you don't have to, but that's also a kind of a point in time where if there is a pre-suit demand, to really stop and think about what documents can and should be provided to the plaintiff that's trying to bring a claim. So the classic categories that we see before we get into maybe some of the newer ones is fund underperformance. And again, that's what we've been talking about, whether the plan is, not on a given month, but on a consistent basis, underperforming against the benchmark. The other one is there's record-keeping fees and investment fees. So the record-keeping fees, it's to the record keeper for the administrative services of account balances and, making payments and distributions and whatnot. Those can be direct, meaning a per person fee, or they can be indirect, meaning a percentage of plan assets. And there's no right or wrong. The cases will say that it depends upon the context, depends upon the circumstance, but you have to monitor it. So for example, if the fee is as a percentage of plan assets, that could potentially be reasonable on day one, but as the plan grows in size and the assets increase, if the fees are increasing exponentially without increase in service, that might be something you want to be in tune for.
And I think on that one, Melissa, I want to comment on that. The other thing you need to be asking real questions, hard questions, because there is indirect fees, and there's also, plans will be set up to pay a per head fee, right? But then there's also all sorts of additional fees, distribution fees, loan fees, quadro fees, maybe indirect revenue sharing, although that's sort of changing in the market. But you really need to ask those hard questions and have an understanding of all that. And again, if you understand that, you've done your benchmarking and you've memorialized it, you're really fulfilling your fiduciary responsibilities. But you need to look at the total fees as a whole and really have a firm understanding of what your record keepers are earning from your plan.
Exactly. And the other thing that the cases talk a lot about is negotiating, because, just because a certain fee is published, plans do have negotiating leverage, and there's also some kind of duty to do some sort of negotiation, or at least try to get the best fee and not just accept what's at face value. Same thing with investment fees. The investment fees on certain funds can be as a percentage. That's called an expense ratio. And there was some litigation. You're not seeing as much of it, but the stocks and funds that have an expense ratio that are more tightly managed have higher fees, whereas passively managed funds have lower fees. And then there's a question of, are you getting your bang for your buck? Is the management causing a better result that makes it worth the higher fees? And then the other big one that we're seeing a lot of lately is this institutional, the share class, retail versus institutional, because retail shares are available to anyone, but the institutional class is right for a larger investor with a larger plan. They can qualify for an institutional class. And as to hear the plaintiffs tell it, the only difference is it's a lower cost. They're getting the same thing for a lower cost. And so as some courts have said, the comparator is baked in. I mean, if you're paying for a higher cost when the same thing's available for a lower cost, the benchmark is there. And again, a lot of times the share class, you may not qualify on day one, but if the plan grows, you need to be attuned for, well, have I crossed the threshold to qualify? And a lot of providers will bend those thresholds. They're not flexible. They're flexible. So can I qualify for the institutional share even if I don't technically have the right number of assets?
Another strategy that I'm a strong advocate for, and we haven't seen large uptake by our clients, is particularly on it relates to record keeping fees, is these issues involve, when you're using plan assets, when the fees are being deducted from the retirement plan. And one strategy is to have the employer pay those fees outside the plan. And then you're not using retirement plan assets, and participants shouldn't be, damaged. And that's something that sort of makes sense to me. And if you, in the big scheme of some of these plans, the record keeping fees are not significant. And so it might be, it's a way to minimize your exposure. And it's a benefit it's certainly a benefit to participants. The hard part is, it's not well understood by participants, and people would rather not pay those fees outside the plan and perhaps reduce the level of employer contribution, even though you sort of net the same amount. But that's a good strategy, and one I think is smart.
Absolutely, because we're talking mostly about the duty of prudence, but there's also, a duty of loyalty and conflict of interest prohibitions. And so when you start paying things out of plan assets, you start seeing allegations of conflict of interest that the plan assets are not being spent wisely. So the Supreme Court has just accepted cert to resolve an issue. So this is a case that's going to go up to the Supreme Court and probably get a decision next year. Under ERISA, Section 1106, it is a prohibited transaction to engage in transactions with a party in interest. So the plan cannot engage in a party in interest. And a party in interest is defined as lots of things, but it also includes a service provider. Well, I mean, you have to have service providers. You have to engage in transactions with service providers to provide services, record keepers, accountants, some other professionals. So ERISA Section 1108 says, well, it's not a prohibited transaction if the service fee is reasonable. If the service is reasonable and the fee is no more than reasonable compensation, which makes sense. The split in the circuits is over what plaintiff needs to plead to establish a prohibited transaction, and whether they have to plead that it was not reasonable compensation just to get in the door. to some extent, just kind of a technical pleading issue, because the employer or the plan is always going to have the obligation to prove that compensation is reasonable. And it's interesting that this is the case that really, like I said, sounds like a technicality of pleading that the Supreme Court accepted cert on. But we're going to expect to see a ruling on, this case involving what is reasonable compensation to a service provider, and what does the plan need to do to show that it's reasonable compensation. And Craig and Molly, I'm going to let you jump in here too, because while most of these cases are involving health retirement plans, health and welfare plans have service providers too. And so this reasonable compensation is something that applies equally to all plans.
Yeah, and I think that's right. In the Department of Labor, this is a focus of the Department of Labor. All these things we're talking about, these comp and reasonable fees and all that. The difficulty is there's some peculiarities involving health and welfare, and you don't necessarily always have to plan assets in the legal sense. And so I think the Department of Labor is struggling at getting their arms around. They'd like to enforce these reasonable comp and reasonable expense rules, but they struggle because of the exceptions or lack of plan assets. But they absolutely apply to health and welfare.
To foreshadow some later points in the presentation, your compensation paid to service providers, even within the health and welfare context, is something that is becoming more of an enforcement priority. So a little bit of a sleeper there, but something that you need to keep your eyes on, despite the fact that there aren't usually assets involved in your health and welfare arrangements.
All right, plan forfeitures, Craig's going to talk about. This is a new class of cases. We're starting to see just filed this year.
Yeah, and frankly, so basically the plaintiffs are alleging that the plan breached the plan fiduciaries breached their fiduciary duty by applying the forfeitures to reduce the employer contributions, as opposed to allocating them and treating them as additional earnings for the benefit of participants. These cases really perplex us, because going back to the beginning of time, certainly when I first started practicing law, there's IRS guidance that specifically says and allows us to use plan forfeitures to reduce our employer contributions, whether those employer contributions are discretionary contributions or they're pursuant to a fixed formula. And the IRS has been blessing plan language like that forever, and it's expressly authorized by the regulation. So we'll see, and I don't frankly understand the plaintiff's arguments here. I get that from a fiduciary perspective, but it seems to me to be flying in the face of what at least I grew up learning and knowing is part of the Internal Revenue Service rules, IRS rules. So do you, Melissa, you want to comment on the LOPR?
Yeah, and part of what Craig is what you're going to see as part of a larger trend across plans and frankly across all sorts of laws is I'm sure most people know that the Supreme Court earlier this year in LOPR Bright Enterprises struck down Chevron deference. And to the non-lawyers on the call, a Chevron is a long-standing doctrine that the courts are going to defer to an agency's interpretation of a statute. If the agency is the expert, we're going to defer to its interpretation of the statute. And in this past year, the Supreme Court said, the agencies don't get to interpret the statute, the judges do. And so we're not going to defer to the agencies anymore. And so not that we don't want to overstate the effect of it. It's not that the regulations don't have a force. Certainly, we would still advise to follow them. But the plaintiffs are now, I think, catching on to this. Maybe there's a loophole. Maybe there's a chance that the court will say this isn't reasonable. I don't care what the IRS said you can do. Because their argument is that when the employer uses the contributions, the forfeitures for its own benefit to reduce its contributions instead of defraying plan costs, it's putting its interests above the plan, and it's a conflict. So it's part of a bigger trend that we're going to see to what extent these longstanding rules are still going to be given deference.
At this point, I don't think we're making any recommendations to change. I mean, there's some strategies we can think of how you might be able to sort of amend your plans to get around these allegations. But at this point, we're really just monitoring the cases and seeing where it goes.
Right, and as of now, none of them have reached any sort of decision point. These have all been filed in the last several months, and we don't have any decisions that have ruled either way.
Let me take this one if it's okay, Melissa. I slid this slide in this morning, and I just it's again, it's not going to affect most of the folks on this call, but it's something I think that committees want to continue to monitor. And again, this even for people that aren't affected directly by this. So there was in August of this year, there was a big class action lawsuit against TIA and Morningstar. And these are involving 403B plans for the equivalent of 401k plans. And the allegation is that, these 403B plans are offering sort of an added asset allocation model where participants can sign up and get some additional advice, either for a fee or maybe even free, about how to do their asset allocations. And I think that's pretty common feature for 401k and 403B plans. And the plaintiffs are alleging that that essentially there was sort of a behind the scenes deal. The Morningstar was hired to be the third party investment allocation advisor, and that they were deliberately basically pushing funds, more money into the TIA funds as part of that asset allocation strategy. So this is something to monitor. Again, this is so for 403B sponsors that have TIA, I think this is something that you'd want to share with your committee. You should certainly be asking questions. They won't be able to share anything that's part of the litigation, but I think asking questions and documenting that you've thought about it and you're understanding and following it is a good, prudent practice. And that would be the same thing for 401k sponsors. Again, monitor your vendors. These big, ginormous record keepers get sued all the time, right? And it doesn't, sometimes there's not much to it, but I think it's a prudent practice to kind of stay on top of that and follow your vendors.
Couple just follow-up types of cases that we're seeing. Outdated actuarial assumptions. For defined benefit plans, there is, the rules require that if you don't select the the sole survivor, if married couples do not select the joint and survivor, then there has to be an actuarial equivalent plan offered. Craig, correct me if I said that backwards. So what is actuarial equivalent? And a lot of times the plans have, the tables or the interest rates in the plan. And what these suits are saying is, if you're relying upon actuarially equivalent rates that were written 10 years ago or 20 years ago in the plan document, those may not be up to date. Lifespans are longer, interest rates have changed. And if you're relying upon outdated figures and assumptions, then it breaches ERISA, it's unreasonable.
And I might say those, when she says 10 years, there's pension plans with, the 1968 or 1971 mortality table. So we don't want to spend a lot of time on this one. And I'm sure the sponsors that have defined benefit pension plans have talked with their actuaries. But this is, again, a topic that you should be discussing with your actuaries and committees and memorializing and being aware of it.
Yeah. And then last one, I just want to note very quickly, ESOP. I don't know how many people here have ESOPs where it's employer stock only. And the Supreme Court has long held that ERISA has the duty to diversify plan investments, but employers' plans, ESOPs with employer stock, are exempt from the duty to diversify. You can have a plan that just has primarily employer stock. The question is, what about the rest of the plan? What about the cash that's in the plan? Do you have to diversify that? If the cash gets kind of larger than you need for your liquidity needs, does that have to be invested and diversified? And again, those suits are relatively new. We don't have a lot of holdings in them, but we have seen some class settlements on some of those ESOP cases. So again, if you do have an ESOP and if there's a large portion of cash that's more than you need for your liquidity needs, it's something to think about if that could be invested. Arbitration clauses. This is another hot topic. And before anyone thinks that we can't spell, the which forum is a pun. A lot of plans, especially the pension 401k plans, have an arbitration clause. And not only do they require arbitration, they say it has to be individual arbitration. And so courts are struggling with what happens if plaintiff brings, before the class action under ERISA, do they have to arbitrate in individual arbitration? And most circuit courts that have ruled upon this, not all have ruled, have said, no, ERISA gives participants a right to obtain plan-wide remedies. They have a right to recover on behalf of the plan, and they cannot be limited to obtaining individual relief. And so they're striking down the arbitration clauses as applied to plaintiffs trying to bring class-wide relief. If you have a plaintiff trying to bring his or her own relief, just an individual claim, that's more likely that the arbitration clause will be enforced. But a petition for cert has been filed. It has not been ruled upon yet, but this will probably get up to the Supreme Court at some point in the near future. So, Craig, you want to kind of summarize the key takeaway from these cases? We're not trying to be scary. We're trying.
Yeah, you've done a great job here. And again, we just wanted to hammer this home. And again, we're repeating ourselves in some ways. It's procedural prudence. That's the way we're going to be judged, right? So, what can we do? We can have our committee meetings. Make sure our committee members attend. Make sure we have charters. Right? We reviewed our charters. We have worked and make sure that our minutes reflect our fee benchmarking on a routine basis. Benchmarking can be a formal RFP, can be a formal informal RFI, and it can just be documentation, right? You want something in our minutes that at least annually that we have worked with our consultants. We've done it ourselves, but we've independently reviewed and are thoughtful about our fees. And document it. And we'll talk about that later. And again, the consultants and advisors that we work with are outstanding. They're absolute experts in their area. The record keepers are outstanding. All sorts of information they provide for us. But don't be complacent. Don't rely exclusively on your advisors. Don't rely exclusively on your record keepers to do everything for you. You need to have an independent perspective and ask hard questions, and be mindful of that. You fulfill a very important role, and it's pretty simple. The way I look at it, it's not your money, right? You're doing it for your friends, colleagues, and peers, and so that's the way you ought to look at it. So I think we are going to turn into some, we're still on retirement stuff. Go hit it, Molly.
Yeah, we got a couple slides on retirement things, but shifting gears a little bit into primarily regulatory updates. So the first one we wanted to touch on is missing participants. And this is a body of guidance that isn't particularly new to anybody. However, for 2024, they are still an official DOL enforcement project, and the DOL fact sheet identified that missing participant investigations were a significant portion of enforcement recoveries in past years. So still happening. And I guess as a way of providing a little bit of background, as most of you probably remember, in January of 2021, we got a whole bunch of DOL guidance explaining what steps plan fiduciaries should be taking to locate and distribute retirement benefits to missing or non-responsive participants. The guidance was helpful, although I think it was primarily kind of a mix of red flags and best practices, so not a lot of bright line rules. Things that have developed since that guidance is that Secure 2.0 rolled out in 2022, and we have two pieces there that relate kind of indirectly to missing participants, ways that the DOL is kind of intervening to ensure that we have fewer missing participants, which in some ways takes the burden a little bit off of plan sponsors. So for example, the first one that I wanted to touch on is the Retirement Savings Lost and Found database. And this one isn't actually, it's not intended for plan sponsors. It's a database that is designed to help plan participants find any retirement savings account that they may have left behind with a prior employer. So they're going to build everything into this massive database. But in order to have a functional database, plan sponsors are going to be required to submit information about terminated participants to the Department of Labor. So what's happened in the past year, 2024, is that we've gotten some additional guidance about how the DOL is going to be collecting that data. So in its current iteration, the only information that they are looking for right now is information for separated vested participants age 65 or older. And that's voluntarily provided. There is now a DOL template for how we provide that information. And the reason that this is happening in 2024 is because there is a deadline, pun intended, of December 29, 2024 that was built into the Secure Act. So that's why all of a sudden we're seeing some movement on the RSLF database. The other thing that came out under Secure 2.0 is auto portability. And this was intended to help employees stay connected with their retirement savings. So as many of you know, as people leave jobs, sometimes they leave behind accounts. They might get rolled, if it's a small balance, it might have gotten rolled over to an IRA. And you end up with a scenario where a participant has like a dozen, retirement accounts sitting all over the place. So this was intended to step in and allow plan sponsors to automatically transfer small retirement balances. That number is like $7,000 or less to a new employer without the participant's consent. And earlier this year, January 2024, we got some new proposed rules and a new prohibited transaction exemption for auto portability arrangements. So just wanted to mention that all of these things are happening, but I think the biggest takeaway is that for plan sponsors, the best practice is still to be proactive and put steps in place that will help the plan maintain contact with participants. So still kind of leading into that 2021 guidance, despite the fact that we have these other things happening in the background that are intended to help with missing participants.
With the extension of expansion of the MRD rule, minimum required distribution rules, and sort of shifted when we first started practice. I first started practice in particular. There was always a push to get terminated people out of your plan, and now there's a trend towards, hey, we can offer lower cost funds and sort of let people leave the money in there till they're 73 years old. So you can see where it's very easy to lose people. So having a process for your former employees is critical.
Yep. The other piece of kind of regulatory guidance we wanted to touch on is the student loan guidance. So just as, again, kind of by way of background, so this isn't necessarily new either. There was kind of a big private letter ruling that came out in 2018, issued to Abbott Laboratories, which was kind of a big deal at the time. However, it didn't really cover some of the issues that arise in non-discrimination testing. So again, Secure 2.0 actually amended the definition of matching contribution under Code Section 401M to include employer contributions made to defined contribution plans on account of an employee's qualified student loan payment, or QSLP, just adding acronyms left and right. So we have subsequently this year, we have gotten some additional guidance. A couple months ago, we got an IRS notice, 2024-63, which I think the biggest things that came out of that notice is that there's a definition for eligible loans. So which loans are eligible for these matching contributions. There's also employees can self-certify that the loan payment satisfies the requirements to be a QSLP. So there's now a certification requirement, and there's some additional guidance, which I think was pretty welcome, on non-discrimination testing. And the notice applies to any plan years beginning after December 31st, 2024. So for any folks out there considering adding a qualified student loan payment matching contribution, there's some good guidance out there to start thinking about that. I think the biggest takeaways from this one is that if you already offer a match on student loan payments, you should be reaching out to your service providers to discuss the new guidance. If you're thinking about doing it, we now have some better guidance for you to design these types of matching contributions. So generally, just review this notice with your service providers to the extent that you're interested in these types of contributions. But primarily, I think that if you already have something built into your 401k plan with matching contributions for student loan payments, that at this point you should be confirming that your plan covers the definition of eligible loans. You need to make sure that you're putting in place a sufficient certification process. And unless you're a safe harbor plan, you should be thinking about how the ADP testing guidance affects your plan. I think now we have a poll question. So I think, is this showing up?
I think you have to hold the little arrow over. She said, hold it over the question or the results.
The results.
I don't know.
It looks like we're moving. We've got 6 people. Maybe people just start. Oh, okay, now we're jumping. So I'll give it another second here.
And then how do you see the results? I don't know.
We're going to the next slide, but we'll wait and see. Okay, so we've got about 50% of folks that have responded to our poll question here. So we will.
Maybe Sylla will give it. Oh, there we go.
All right, so these are obviously an incredibly popular function of 401k plans at this point in time.
That's consistent with my experience. I don't have a single client that's done it.
Yeah, we don't have very many clients, although it might be gaining popularity. I think it's been a little challenging to lean into these just given the lack of guidance. So perhaps in coming years, obviously there's a lot of folks out there with student loans. Some food for thought.
It's a big issue, and I think it will be. It's sort of like I remember when Roth came out, right? No one was adopting Roth contributions. Now it's next nature. So we want to move on to the health and welfare space. This is just some quick reminders, and I'll let you all read these on your own. But sort of important things that we don't forget, and hopefully you can tick them off. I want to emphasize again, make sure it's so easy. You've met as a plan committee in 2024, and then you forget to finish your minutes, right? And make sure that, I'm sure that you talked about the fees. Make sure that you have a blurb, and you don't have to go into great detail, but make sure you have some self-serving to memorialize that, hey, yeah, we did talk about fees. We reviewed them and analyzed them, okay? So the next slide, here's some more additional year-end stuff. This is a reminder, you still have to adopt year-end discretionary amendments. So if you made any changes this year, you need to do the discretionary amendments. All the Secure Act stuff, super confusing. It doesn't have to be, the amendments to your plan, even if you've implemented, don't have to be adopted until 2025 or even later. And I'd bet money that it's going to be extended, okay? With that said, it's very confusing as there's some really nuances about distributions and whether there's different opportunities for different types of distributions, domestic abuse distributions, disaster relief, emergency withdrawals, a number of those. You need to make sure that you understand what you adopted. You probably were slid something by your record keeper as to what you're either going to elect or default into various things. So you want to make sure you memorialize that what you've adopted, and you need to update your SPDs or summary of material modifications to reflect that. Okay. The other thing is we continue to see the misuse of definition of compensation, which is a pain in the rear. So if we don't apply the proper definition of compensation, then it creates issues for us, for correction issues and such. So that's a very important year-end reminder. So we are going to switch over to health and welfare matters and kind of go through some slides with again, a year-end compliance focus.
Okay, so and this is actually kind of as we mentioned earlier in the presentation. So we have years ago, in April 2021, the Department of Labor issued cybersecurity guidance. And just at a very high level, you had to select, monitor service providers taking into consideration cybersecurity, periodically review your cybersecurity programs, the cybersecurity programs of your service providers, review the term of the service agreements with respect to DOL best practices, and require ongoing compliance with those cybersecurity and information security standards. Also had a duty to educate your participants and beneficiaries who manage their benefit accounts online. Come 2024, because we long assumed that this was just for retirement plans, but in 2024, the DOL pulled a fast one on us and clarified that this is in fact intended to cover all employee benefit plans, including health and welfare plans. So this shouldn't be, ideally you're already doing this for your retirement plan. So this should be kind of an easy, like we're familiar with cybersecurity best practices, and we can just kind of shift those over to your health and welfare benefit plans. But they also added some additional updates. So you're now supposed to find out if your service provider has insurance that would cover losses caused by cybersecurity and identity theft breaches. Confirm that your service providers deploy phishing-resistant multi-factor authentication practices. And also you need to recommend, and this is just a hot tip for everybody sitting in on this seminar, you need to be using longer passwords, not common passwords, and you got to change your longer passwords annually instead of more frequently. So the ever-evolving world of changing your passwords, the DOL has you covered. So at any rate, the biggest takeaway here is that your health and welfare plans need to start implementing these cybersecurity and data privacy best practices in addition to your retirement plans. All right, so everybody's favorite health and welfare topic, mental health parity. So wanted to just briefly provide the landscape. Mental health parity, the Mental Health Parity and Addiction Equity Act rolled out in 2008. So this stuff is not necessarily new, but at its core, the Mental Health Parity Act requires coverage for mental health conditions, which includes substance use disorders, to be no more restrictive than coverage for other medical and surgical conditions. A whole bunch of acronyms in the mental health parity world. We could do a whole hour-long plus seminar on mental health parity and what's rolled out recently. So we're just going to cut this at a very superficial level. But what we've discovered over the years since 2008 is that it was much easier to comply with these straightforward aspects of the Mental Health Parity Act that relate to cost sharing and kind of numerical limits. So you could hold up your plan document and say, look, everything's in parity, like the numbers all match. However, the DOL and the other agencies that regulate in this area, we're starting to see that that this wasn't really necessarily like the way that things were being implemented wasn't always in parity. So in 2021, under the CAA, we got some new requirements, which those who have tuned in might remember that we now had to, that regulators were required now to investigate group health plans and health insurance issuers' compliance with non-quantitative treatment limitations, or NQTLs. And this is kind of the stuff that can't be measured in numbers. So your medical management standards, formulary design for prescription drugs, network tier designs, all of the stuff that is non-numerical is an NQTL. The CAA also came in and said, oh, and by the way, if you aren't doing a good job, we're going to shame you. So we're going to publish the names of non-compliant plans and issuers in a report to Congress. It's kind of a stick if you aren't following the rules. They also said, we've got to figure out a way to provide guidance on how to properly document NQTLs, because again, it's not as easy as just providing the numbers. So in the meantime, everyone kind of panicked, ran around with their heads on fire because no one really knew how to document a comparative analysis with your NQTLs. A lot of head scratching. So conveniently, excitingly, we've got some final rules in 2024. We got some additional rules that are implementing the CAA provisions. So I'm going to cruise through these. There's a lot living in these rules. Again, this is really high level, very superficial. But I think it's important to know that there's a potential expansion of mental health provider networks and mental health services that you're going to need to bake into your, if you're a self-funded plan, that you're going to need to bake in there, or if you're insured, that you need to be having conversations probably with your insurer that they're in compliance with these. That with respect to the provider networks is that they're going to start looking at network composition standards, which is essentially the requirements for provider admission into a network. Takeaway there is that you may need to expand your network or confirm that your TPA verifies an adequate network for your plans to ensure adequate access to mental health providers. In addition, we've got a potential expansion of mental health services. And this is probably, that strikes me as probably the most controversial piece of these new rules is the new meaningful benefits standard, which is that if a plan must provide a standard core services for each mental health condition or substance use disorder covered by the plan in each classification in which a standard core service for a medical condition is covered by the plan. And that's kind of a mouthful, but at its core, your plan may need to expand the scope of covered mental health and substance use disorder services to start covering services in additional classifications to ensure parity. So we've kind of got some expansion there. Also have some welcome guidance on NQTL comparative analyses. However, maybe, they've made it more complicated. So we've got some new specific data points that need to be considered in the analysis, which are broadly outside of the hands of plan sponsors. So it's really important that you're listening and talking to your service providers to comply with an NQTL analysis. It's also important that you're thinking about that now, because this rule rolls out effective next year. So starting your next plan year starting in January 1 after 2025. And there's pretty tight timelines for having to provide the comparative analysis. So if a participant requests it, you got 30 days. If the regulators request it, you've got 10 business days. So those are some pretty tight timelines. You can't just, for a while you're saying, I don't know, see if the regulators show up and ask for this analysis and then provide it. But at this point, you can't do that. We aren't going to be able to get an NQTL analysis in 10 business days. Stay tuned. Apparently, we're going to be updating the mental health compliance tool. And we have like 8 minutes left, so I'm going to punt on the, and then in the meantime, this is, I'm punting back to Melissa here because this all covers the kind of regulatory aspect of like what the agencies can come in and enforce, but that's not the full story here because you can also get sued.
Yeah, and I think that, especially if the rules don't even take effect for 25, 26, the lawsuits are going to keep coming based upon current practices. Real quick, because we still have a lot to cover. The big takeaway is that when the mental health treatment limitations, it's not just, facial discrimination, but it's also as applied and processes. So you see a lot for residential and mental health treatment. Is the plan applying more stringent standards for that than residential, physical or rehab treatment? And so just want to make sure that not just that on paper the standards are the same, but are they applied, and so that the results are being consistent and the processes are consistent.
Great. So Melissa and Molly, I think I'm gonna fly through these next slides, and I'd ask that you guys comment and chime in here. I want to be respectful of everyone's time, so we'll go pretty quick here. So this is just an important update. HIPAA privacy and security. The Biden administration, of course, in response to its disagreement with the Supreme Court's decision on Dobbs. So they've expanded and doing what they can to protect reproductive rights. And so there's new HIPAA rules, okay? And so this is an excellent reminder. Dust off your HIPAA privacy policies and procedures, okay? You need to update your privacy policies and procedures and your notices to participants to reflect these new reproductive rights, okay? And we've provided some model language here as an example. Essentially what they're saying is you can't disclose someone's information dealing with reproductive rights in connection with a criminal investigation. So as an example, if someone were to leave Texas and to come to Kansas, as an example, to have a procedure, a group health plan, because it's lawful in Kansas to have an abortion, you wouldn't be able to disclose that. Okay, and that's what this language is saying, and you're supposed to update your notices. So it's important. The next thing quickly here is there's some additional guidance that just came out in the last week or so, and this is proposed. Okay, so this is 2026, not for 2025. But again, the Biden administration, the regulators are trying to expand reproductive rights, and so beginning in 2026, there's opportunities that plans are required to provide for contraceptive coverage without a prescription. Okay, and so over the counter drugs would have to be covered by your health plan. They've also issued some additional guidance with sort of retroactively dealing with the similar types of expenses that can be preventive benefits that can be deducted from HSAs and FSAs over the counter. So again, kind of going back, they've gone back and forth with that from a tax policy, but there's been an expansion on that here recently too, and that's effective immediately. Just as a reminder, our annual gag clause attestations are due December 31st. And so hopefully you all are in compliance with that, but a good reminder. Melissa, do you want to tackle this in 30 seconds?
Yeah, basically, the Supreme Court, ERISA preempts state laws, and in 2020 issued the Rutledge decision that kind of let some laws governing PBMs and other healthcare entities survive preemption. So you've seen an increase in states trying to regulate some of these health plans. And a case just came out of the 10th Circuit that pushed back and found these laws were preempted by ERISA. And we only put this up there just because there is a petition for cert, and the preemption issue may come back to the Supreme Court, and we may see a pushback on the laws they're getting through. Is that 30 seconds?
Good job. Okay, so here's our year-end action items on the health and welfare side. Again, Molly's emphasized this as a point, is make sure you have a game plan for mental health. It's the number one priority top priority, maybe the number one priority of the Department of Labor. So you want to have a game plan. Again, review your committee minutes. You need to adopt discretionary plan amendments. There are some disclosure rules, right? And hopefully you're doing this as part of your open enrollment. You're communicating changes in your design and such, but that's very important to do this. And again, we can get sloppy on the health and welfare side and have fewer minute committees. It's less formal. Sometimes it's handled by different groups, but it's very important on the health and welfare side to memorialize, just like you would on the 401k side. Okay. Reminder about our summary annual reports. Yes, we still have those. Update SPDs, RAP plans, SBCs. I want to emphasize 2 points here, and I've had some experience over the last couple of years with this, is for self-funded plans, make sure you talk with your consultants, talk to your stop-loss carriers. Many of those plans have a paid and incurred policies. And so if you want to make sure you have a clear understanding of your large claims, and make sure that you have a strategy to get those large claims submitted before your deadlines, or you can be exposed on your stop loss. And so it's a very important action step. And Melissa has been involved in that as well. The other thing is, this is another common practice is we have leave of absences, and we have these leave of absence policies, and they're becoming much more difficult to monitor and apply because of all the state law rules. But you need to absolutely make sure that our leave of absence policies are aligned with our health and welfare plan documents. So if we're extending coverage when people are out on approved leaves, we need to make sure that our plan documents are aligned with our leave of absence policies. And it's important when it's important. Okay. When you have a jumbo claim and it becomes critical, that's when this stuff comes to light. Okay, nobody cares on the little stuff, but when it's a major claim, that's when this stuff can come back to burn you. The last two things here, this is a plug. Molly and I are going to, and we'll relieve Melissa. We won't make her do this, but we're going to do another presentation yet this year on the ACA reporting. We continue to see, it seems so basic. We rely on our vendors, but we continue to see errors and issues with the ACA reporting. And we want to slow down and take an hour or 50 minutes or so and talk about, look back in whether our documents are consistent with what we're doing. So we thought it would be a good and interesting topic for another lunch and learn. Okay, quick, so we can get our CLE credit. Can you all, if you have conducted a non-quantitative treatment limitations analysis with respect to your mental health? We may have lost everybody. Okay. I'm going to keep talking here and then we'll get the results. Two other quick reminders, sort of off topic, as Molly didn't like these slides, but I slid them in there. If you have non-qualified deferred comp plans, 409A plans, 457B plans, let's make sure that any payments that are due in 2024 are in fact processed during 2024. Okay, we may have had a payment date earlier in the year. People may have terminated employment. It's a very common mistake. Okay, so we need to make sure, and the tax consequences are significant. So that's another action step. My last slide is, again, may not affect many people on this, but for those who took an employee tax and retention tax credit, the COVID relief in 2020 or 2021, there's an IRS voluntary program. If perhaps you received the tax credit and you don't think you may not have qualified based on some subsequent IRS guidance, there's a voluntary program that ends November 22nd. So that's an important deadline. With that, thank you very much. Contact us. We very much appreciate your all's time, and have a great day and a great Halloween. Thanks.
Thank you.
Thank you.